I've been asked to speak on trade unions and the law. I don't have to apologise for the fact that I'm not a lawyer. I think there is a valid reason why in this forum in particular we could have somebody with a trade union perspective on the issues. This may overlap somewhat with what Ivana Bacik has to say to you later. She is, of course, not just a lawyer but an esteemed academic on the law. But I want to present it as a review of trade unions and the law, or how the law has dealt with trade union rights, and particularly the constitutional right to form unions. Traditionally, on these islands, and including Ireland, we have described ourselves as having and enjoying a voluntarist system of industrial relations. The term implies that it's a voluntary process. There's minimum input from the state or the law courts in the processes of collective bargaining. And that's the way we used to present it, but things have changed. As Jim has pointed out, there is a lot of European law, a lot of individual rights law, employment rights law, has come in mostly and nearly exclusively at the behest of the European Union and our membership of it. And this has overlapped into what would have been some of our activities in the past. In addition, of course, you have the courts more active than they used to be in dealing with trade union and industrial disputes law, and that's something I want to talk about. The courtroom has been a cold chamber generally for trade unions, and that's one of the reasons why the voluntarist approach was adopted in the early part of the last century. But what I want to talk about is how the rights and provisions for protecting workers, particularly in the area of collective law, have been eroded over quite some time, but most especially in recent years. I call my talk an emasculation of rights, because I think that's what we're being looking at, the emasculation of long-held laws and constitutional provisions that were intended to actually support trade unions and their activities. I look at the early origins of trade union rights, the mid-20th century judgments that began the process of erosion, and the recent findings of the Supreme Court, and what the combined effects of all this are, and effectively hope to demonstrate that the end result of a lot of judgments of the High and Supreme Courts is not just to erode it, but to give meanings that are almost the opposite of what was intended by the people in terms of the Constitution and by the legislator in some cases in regard to the making of law. Now, if we can learn how do I push this forward? I should have tried this before I... All right. It's just this. I thought there's a click I can give it, a right click, no?
Should be, yeah.
Okay, there we are, sorry. Got it now. I'm taking it back quite a bit to the 1906 Trade Disputes Act, and there's a reason for this. In a way, it was a legal emancipation for trade unions. You had anti-combination laws throughout the 19th century, and you had, starting from 1876, a series of reforms that began to allow for unions to operate freely, protections effectively in the law. But at each turn, as the Westminster Parliament passed acts to provide for legal bargaining, the right to hold disputes, the judges kept and lawyers kept undermining it, finding technical reasons why the law passed by the Parliament was in conflict with some aspect of common law and common law rights. that culminated in the passing after a major dispute in the Taff Valley case of the 1906 Trade Disputes Act. It was an extraordinary act. It's a very short act. And interestingly, the bulk of the golden formula, as it's called, that's contained in that act, is still in our legislation. It's in the 1990 Act, in the important sections of the 1990 Act, word for word. But there's a few exceptions of things that weren't carried over. But by and large, the wording that was determined by Westminster Parliament in 1906 is still in our law. The important thing about it, by the way, when I mentioned the golden formula, it gives complete immunity for trade unions against being sued under any grounds. I mean, this was quite extraordinary at the time, and it's still extraordinary. And this existed until 1990 as the framework for our legal system of trade disputes. You could not sue a union. Now, it was probably in some ways unconstitutional because, like, if somebody fell down the stairs in union premises, they should have the right, presumably, to take a personal injuries case. But in any event, that element, that exclusive element of it was taken out in 1990. But there's still a complete immunity from any actions once the actions undertaken by the union are in furtherance of or in contemplation of a trade dispute. But it's important that these are not rights. These are not legal rights. In other countries, there's a legal right to strike. In Britain and in Ireland, there is no legal right. When unions participate in industrial action or when they organize some industrial conflict, they're actually breaching the law. They're breaching contract law. There's a conspiracy involved to undermine the employer and his rights to conduct his business. What is provided is immunity from prosecution. Now, that's still the case. There was discussion in the 80s, maybe I think it was late 80s, when Rory Quinn was a minister in a previous government. I think he was Minister for Labour at the time, and he did discuss with Congress the possibility of abolishing the immunities and imposing rights instead. But the trade unions generally felt at the time, and I was peripheral to these discussions, but I do remember them going on, that we're happier with what we know. There's a body of law built up that protects us. If we go into new territory, the courts may find new ways of undermining these hard-won rights. So that opportunity was not taken. But it may explain some of the judicial hostility, or at least explain a residual caution in dealing with unions, in the sense that there's a knowledge that unions are really tainted with illegality in their construction and in their activities. And that may explain some of what we're going to hear about later. Just to remind you about the constitutional provision, the Constitution was passed in 1937, wasn't it? And Article 46.1 states there are three fundamental rights listed, and one of them is the state guarantees the liberty for the exercise of the right of the citizens to form associations and unions. Now, it went on to say that laws, however, may be enacted for the regulation and control in the public interest of the exercise of the foregoing right. And there are various acts that have limited that right by imposing charges on the formation of unions and so on. It seemed to be in the public interest. I won't go into that, but it's important to look at this very short wording of the right of the citizens to form associations. Note, it doesn't say join unions or associations. It says form. You might think that's a peculiar. Now, it does exist in the ILO conventions that come from around the same time, too. But it's the possible or probable reason is that if you say workers have the right to join a union, that might seem to impose that right upon unions who didn't want to accept somebody into membership. Now, those of us that come from a general union background might be surprised to hear that the union mightn't want to take you into membership, but this is more important in the craft union sector. If you don't have the right trade qualifications or other factors, you might not be accepted into that particular craft unions. And that was borne out in a case later where somebody attempted to insist upon his right to join the Amalgamated Society of Woodworkers. And the courts ruled that a right of association works two ways. It has to be an agreement on both parts, and there's no right in the Constitution to join a union. There's only the right to be a part of a union, presumably if that union would accept you. So that's the reason why the word form probably is there. But it's generally assumed that you've a right to join a union already formed. But the first major case in which the courts were asked to judge and make an interpretation of that section of the communication, of that section of the Constitution, was in a case called Fitzpatrick versus the Educational Company of Ireland. Fitzpatrick was the General Secretary of the Irish Union of Distributive Workers and Clerks, no mandate. And the union had a closed shop agreement with the Educational Company of Ireland. Not sure where they operated from, but I presume they printed school books and various things. In Talbot Street, that's what I thought, yeah. They obviously moved out if they ever did live it on later. But somebody had joined and decided he didn't want to, or exercised as he felt his right not to join the IDWC, and the union put pressure on the employer to force him to join the union in line with agreements. And pickets were put on the company's premises to try and do this. There was an injunction was sought and granted, and the case went all the way to the Supreme Court. And the Supreme Court judged that, by a majority verdict only, that the freedom to join implies a corresponding right not to join. In other words, the right to associate has to be balanced by reasoning with a right not to associate. And I suppose that's fair enough, but getting back to the word join, it doesn't actually say in the Constitution you have the right to join, so it is somewhat a stretched reasoning. And it's not an unreasonable kind of extension of the meaning of the Act. But when the court ruled that you had a constitutional right not to join a union, it seems, and forevermore, that right is unconditional, whereas the right to join a union is hedged in by conditions. Apart from public order, apart from other things, the state can pass laws, as it does, to constrict that law in certain ways. But once the judgment was made that there was a right not to join a union, that right is unconditional. They didn't say, but the state may in certain cases restrict your right not to join a union. It is simply an unqualified right not to join. So this was the start of a process where something intended to allow for one thing has become more predominantly its opposite. And by the way, there are potentially valid reasons why people might be obliged under certain limited circumstances to join a union. I mean, if it's a condition of employment. And it was frequently in the past employers who sought as a condition of employment that you join a particular union, because what they didn't want is rival unions competing for members on the basis that we'll get you more money than the other union. So that would have been in the employer's interest, but a condition of employment doesn't seem to be sufficient to warrant a compulsion to join a union. And judges would have known, of course, there are many situations where people are compelled to associate within societies. The Law Society is just one example. barristers have to be a member of the bar. So obviously that must be in the public interest somehow. But so this was in 1961, early on. And but it was another 20 years before we got to a situation where a major decision was taken. And that's in the case of Abbott and Whelan versus the ITGW and the Southeastern Health Board. This was a case where I think a group of ambulance drivers in Cork, for whatever reason, they were dissatisfied with the service, or for whatever reason, they left the ITGW and joined the ATGW, now Unite, etc. And IT is SIP to us, So, and then they basically sought negotiating rights with their employer, the Southeastern Health Board. And the Southeastern Health Board refused to give them negotiating rights. Basically, they were under pressure from the Irish Transport. And so the discontented members went to a lawyer and took a case to the High Court. Now, it wasn't a case backed by the Amalgamated Transport. I can't remember now how much they were giving them a nudge and a wink, but these matters are normally dealt with through the Congress machinery. There's a disputes committee in Congress that rules on these things, and you would have expected unions to deal with the matter to finality at that level. In any event, the High Court determined that the right to join a union placed no obligation on employers to deal with that union. Now, it's a landmark judgment, and we'll come back to it in a moment, but I have to say that at the time, and I was a junior member of Congress at that time, and it didn't raise any great alarm bells initially. It was a group of workers setting out to go to court when we felt it should have been dealt with through the internal procedures. Union recognition wasn't a major issue at the time. There was occasional disputes with what Kevin Duffy will usually refer to as rag and bone merchants about union recognition, but by and large, multinational companies, for example, when they came into the country, and I mean, Apple would have come into Cork around that time and signed up, with the Irish Transport in a single union agreement. And to this day, I think it still has representational rights there. But it changed, of course, within a few years. What was his name? Digicel in Galway? What was it? There was a company in Galway, anyway, his name has just escaped me for the moment. They actually signed a union agreement with the Irish Transport too, but then they did their best to persuade their new employees not to actually join. And that was the start of a process. The IDA changed their attitude to, up to then they were encouraging employers to sign up to the union. That's the way we do things in Ireland. They wanted to avoid another dispute like the AE dispute, which was a nasty, violent dispute in Limerick in the late 50s, early 60s. But they changed their view. The Silicon Valley had become hostile to unions, so that changed the scene in regard to union recognition for foreign companies. But so then this landmark judgment, as it's now become known, became a tool by which employers could avoid unionization, a legal tool. In other words, if we're not obliged to negotiate with any union. Now, when you think of it in the case of a denial of representation, as a thing from a case involving which union do we want to be represented by, then the issue becomes a much different issue. Here we have now, with non-union companies, a denial of representation, irrespective of what proportion of people wish to be represented. Using the judgment of Abbott and Whelan, there is no obligation on any employer to deal with a union, whether or not their employees are members of that union. So then it becomes a denial of representation. Now, if you go back to the Constitution, why was it put there? Why is there a provision in our Constitution that gives workers the right to form unions, to associate with unions? They don't do it because they love unions. They don't do it, very few, out of a great commitment to a movement. They do it because they want to be represented in negotiations with their employer about the terms and conditions of employment. And if the union can't do that, the union is of absolutely no use to them. Now, in the past, there was a way of dealing with that. And you serve strike notice and you try to force the union. That's traditionally the way it's done. It's become more difficult to do that, partly for legal reasons. If you're forcing an employer to recognize a union, are you doing something that's unconstitutional? But in any event, workers nowadays seem less inclined to take industrial action, even in solidly unionized employments, not to talk about, where they're just establishing themselves. So it seems that from the Abbott and Whelan judgment, which has been reiterated by the High Court and the Supreme Court on a number of occasions since, that the provision of the Constitution dealing with the right to formation is absolutely worthless. It's empty words. And is that what the law, the Constitution intended? I doubt it. There's something called the Golden Rule of Interpretation in law, and it was reiterated by Justice Denning before she was Chief Justice in an unrelated case. And she said the literal rule, this is the rule of interpretation of statute or constitution, presumably, should not be applied if it obtains an absurd result, which is pointless and which negates the intention of the legislature. Now, it would seem to me this is a perfect case in terms of interpreting the Constitution of applying the Golden Rule. What's the point of an interpretation that makes the provision worthless? But it seems in the judiciary, when it comes to dealing with interpreting the law that provides support benefit to union activities, to collective activities of workers, as distinct from individual rights, in this instance, they're very restrictive in their interpretation process. If the precise meaning of the law or the Constitution doesn't say you have these rights, then you don't have them. It can't be interpreted in any other way. In other areas, when it comes to interpreting against a trade union, they seem to be activist in their approach. In other words, interpreting in a way that makes sense, but in a way that frequently diminishes rights historically available. So the Ryanair judgment. I'm not going to reprise the Ryanair judgment. It's not my task, but I want to look at the consequence of that judgment and some of the outcomes that resulted. The case dealt with the Industrial Relations Act 2001 and 2004. These were two pieces of legislation that were basically negotiated within two national agreements, two social partner agreements. I was involved in both of them within the national talks, as Jim would have been also as a member of the Executive Council. They were a great compromise to deal with the issue of representational rights in the absence of real rights derived from the Constitution and the total reluctance of government, encouraged by the IDA and IBEC, to consider anything that put into law collective bargaining. It was the product of a high-level group initially, and it basically said, okay, if there is no union and no collective bargaining, if there's no union recognition and no collective bargaining in the company, then you can go through the labour courts with claims for improved pay and conditions, and the court will deal with it and make a determination that's mandatory on the employer in relation to the pay and conditions. So it's a way that unions can negotiate improvements through the labour court process. But it doesn't include collective bargaining. Now, in the Ryanair case, the central issue to be determined was whether or not Ryanair already indulged with collective bargaining. If it did, then Impact, the union, was not entitled to take a case through these procedures. And that was the crux. Now, I won't go into the rights and wrongs of that, but basically the High Court decided that the Labour Court's process for dealing with the case was insufficient and effectively unfair. The reason being is that management staff gave sworn evidence at the Labour Court hearing about the fact that there was collective bargaining, as they decided to call it, and there was no sworn evidence on the other side. There was no pilots brought forward to swear anything different to that. And as a result, the Labour Court was wrong to judge the case without the opportunity of hearing sworn evidence on the other side. So the appeal was upheld. It didn't find the acts unconstitutional in any sense, but what it did was impose court-like provisions within the Labour Court for dealing with a case such as this. It was open to Impact, therefore, to go back and have the case reheard under these new arrangements and procedures in the Labour Court. They never did so. And in fact, the Act has been largely obsolete. There were a couple of cases taken last couple of years by the CWU, but by and large, it's a redundant piece of legislation. I don't know if that's what the Supreme Court had in mind, perhaps not, but it's obvious to anybody who's been involved in these type of conflicts that it would be redundant. It takes courage for a group of workers in a company that's absolutely hostile to trade unions to put their head above the parapet. Mostly what they do is they go off secretly to a union office and get advice from an official. And he'll tell them, well, it's no good if there's only 2 or 3. You come back to us when you have, a good few, and then we'll see what we can do for you. And so they go and try and canvass among their colleagues. Usually the employer finds out there's something going on. But in any event, there's an attempt at anonymity. So what the Ryanair judgment imposes now is the requirement not just that these people are known, but some of them must place themselves in a witness box, swear an oath and give evidence and face cross-examination by the best lawyers money can buy, very hostile cross-examination. This is the way the Labour Court operates now in regard to any legislative rights case that comes before them in employment law. Part of my work now, I do little bits of this, and as an expert witness face cross-examination. But it's one thing for somebody, a union official, to do this. It's another for a worker whose aspirations are to make a career out of a job he's in the hope he might or she might get some promotion, within a few years, move up the ladder, get a little more income. And to be seen as the enemy within, to be hauled over the coals by liars, that's a total deterrent of anybody to go through these procedures who's in a company which is hostile to unionization. So, as I said, the acts are virtually obsolete. And it's interesting that in the different forms of legislation that exist in the United States and the United Kingdom, and in Canada and other places, anonymity is preserved. They're not easy laws. You have to get a majority of the bargaining unit signed up to the union. But the union doesn't have to give the names to the employer. The union just has to give the membership list to an independent body to verify, to say, yes, we have looked at the figures and there is 55% and therefore they're entitled to bargaining rights. They understand that anonymity is important. Is it that the judges don't understand that, or is it that they do or don't care? I suspect their life's experience doesn't allow them to do that. The main judgment in the Ryanair case was given by Justice Kagan, and one of the quotes that it's been quoted a lot since, in his written judgment, which all the other, and this was a unanimous judgment at the Supreme Court, all the other judges involved joined with him in this. It says, as a matter of law, Ryanair is perfectly entitled not to deal with trade unions, nor can a law be passed compelling them to do so. This is extraordinary. Now, I have to explain that this is generally regarded to what's called a judge speaking obiter dicta, a Latin term which means a by the way saying. It doesn't have the strength of a legal judgment that's mandatory. But there's lots of evidence that this represents the view of the bench in the Supreme Court, from other things that have been said. So what he's actually saying is employers don't have to negotiate with a union, but he goes further. He said if you bring in a law that allows them to, even under limited circumstances, even if they've got 100% of the workers in their membership, it'll be struck down as unconstitutional. This would make us unique in the world in any democratic country. But this is the opinion of a member of the Supreme Court and possibly the members of the Supreme Court. So it puts us in a very dark place in terms of trying to get rights in an Irish courtroom. As you know, the registered employment agreements were struck down. Initially in 2011, the operations of the joint labour committees were found to be unconstitutional. Now, it has been rectified somewhat because the Act wasn't found to be unconstitutional, but the operation of it was, because there were no clear guidelines issued by the legislature, and a new Act has been brought in and the JLCs are being restored, but with less levels of protection than previously. The Sunday premium basically has been largely eliminated. More importantly, last year, the registered employment agreements were found to be unconstitutional as a result of a case taken by a group of electrical contractors who were not part of the CIF kind of contractors group. Now, the registered employment agreements are a provision largely in the construction area and in contracting area, where groups of workers who by their nature are all temporary employees, moving from one building site to another, from one kind of project to another. It's if all the major employers in that sector and the unions representing the vast bulk of workers in that sector agree a collective agreement and register it with the Labour Court, then it has the force of law. It's obligatory on all the other employers. CIF always signed up to these agreements because it meant they weren't being undercut by the fly-by-night employers, unions, because it didn't lead to a downward spiral in pay and conditions. That now has been struck down. The consequence of this, we have to wait and see. If it's written into people's contract of employment, they are protected, at least for the moment, but new employees are not. The reason being is that the 1946 Act on which this is based it gives too high a level of delegation of powers away from the Oireachtas. I mean, when you think of the institutions in this state that are given carte blanche in regard to the confinement of children in industrial schools, a whole range of things that has never been struck down by the courts in any way. And this minor collective agreement that can be argued to have a common good, a public good in it, has been struck down. After 70 years, this kind of protection has been abolished. It's extraordinary. Justice Fennelly, I quote him to say he believed that enforceable collective agreements appear somewhat anomalous today. They're not anomalous. They're the way business is done virtually throughout Europe. In Germany, in Belgium, and the Scandinavian countries, there are sectoral agreements. And when the unions and the employers in the sectoral agreements agree rates of pay, it applies to all employers in those sectors. But somehow it's anomalous today. It seems to me that because we have a common law system, and because sectoral agreements were abolished under Thatcher in Britain, that the only place they tend to look is to Britain. You know, a lot of their judgments are quoted in relation to British law. We're a member of the European Union. We're a member of a common currency area, which Britain isn't. So that's another major disappointment. In summary, it seems that the qualified, and it is a qualified, constitutional right to associate with unions has turned into an unrestricted right not to join unions and no right to be represented by unions. You can join, but you can't be represented by them with your employer if the employer decides not to. And so the fundamental right has proved to be worthless. The Labour Court has had to replicate adversarial court sittings when dealing with legislation. Collective agreements that have given protections to vulnerable temporary workers have been abolished, and individual rights are replacing collective rights. The provision in the Constitution was effectively a collective right. Form associations and unions, that's collective. But I think the judiciary are very unhappy when it comes to collective rights. I'm close to the end now, but why? And you may have opinions as to why. One of the reasons might be that lawyers and the law is steeped in the classical liberal individualist philosophy. You know, that is all about the individual. And a company, a registered company, of course, is an individual in law. But it ignores the power imbalance between an individual worker and a corporation. Perhaps the unions are still tainted with the illegality I spoke of at the beginning. Perhaps the judge's life experience may not provide a full understanding of the power relationship within workplaces. Justice Gagan, I mentioned, who gave the Ryanair judgment, at least he led the Ryanair judgment. He's a Supreme Court judge, who's retired now, but he was then, who is the son of a Supreme Court judge. He's married to a High Court judge whose father was on the Supreme Court previously. They are immersed in the law, and I'm sure they would see themselves, and others would see them as giving valuable service to the legal system in this country. But what the hell would they know of the difficulty of workers in companies where the Michael O'Leary or its equivalent is the boss? It's beyond their ken, I imagine. Perhaps I'm wrong. Perhaps there are changing social values, they might argue, they're applying. And all of this has been happening in a situation where international treaties, ILO and European conventions are there that are saying the opposite. The ILO convention, which we ratified in 1955, you can see it there. It states that workers shall enjoy adequate protections against acts of anti-union discrimination in respect of their employment. The Ryanair case was born out of a situation where the pilots were being told that you have to sign a form. We'll pay for your training on these new Boeings, which was, I don't know, 8,000 or 10,000 euro. But if ever we have to recognize a union, you have to pay it back. That was how the dispute arose. That's discrimination, an attempt to discriminate against union representation, which seems to me in flagrant contravention of Convention 98. Article 4, measures appropriate to national conditions shall be taken where necessary to encourage and promote the full development and utilization of machinery for voluntary negotiations between employers and, that should be employees and employers. Employers or employees' organisations, that's right, and workers' organisations with a view to the regulation of terms and conditions of employment. That is ignored. But also, there's the European Convention on Human Rights, which is now built into the European Charter. It's part of European law. And it says everyone has the right to freedom of peaceful assembly and freedom to associate with others, including the right to form and join unions for the protection of his interests. How do you protect your interests? By dealing with the employer. And in a recent judgment in 2008 against Turkey as a state, the European Court of Human Rights, now this is the Strasbourg court where Louise O'Keeffe won her case recently, it seems. It's under the European Convention on Human Rights. It's not the European Court in Brussels, but nevertheless, the same provisions exist in European law. They determined that the right to collective bargaining has become an essential part of the freedom of occupational associations. This is part now of our framework of law, because we pass European law into law, and in fact we usually have to vote in a referendum to change our constitution to allow it to. So it's effectively part of our constitution. And this was in our constitutional arrangements when the Ryanair judgment was made, but there was absolutely no reference to any member of the judiciary to the European Convention on Human Rights, even though it's signed up to by Ireland. Maybe they didn't know about it, or maybe they didn't like it. I don't know. Finally, I think the European Social Charter contains similar provisions. As for a remedy, well, there is the programme for government, and we have to wait and see. It is a provision in the programme for government to bring in laws that give effect to the European Charter, the European Convention provisions. Now, what they'll be, we don't know. There was rumours that the leader of the Labour Party at the last party conference was going to say something about this, but he didn't. One suggests that there are difficulties. The minister directly involved would be Richard Bruton. We don't know his view on this yet. So we'll wait. But it's possible it'll happen just before an election, which it won't be the responsibility of this government at all. Strasbourg or Brussels, take a case. Now, in fact, just recently, Congress announced that itself and the TWU are taking a complaint to the European Court of Human Rights on the Registered Employment Agreement decision, McGowan decision. So that will be interesting. And the person who's assisting him on this, John Hendy, QC, he's an English barrister, Queen's Counsel. Why, I'm not privy to all these things, of course, but maybe Dave Begg, when he's along, might tell you, but why nobody from the Bar Council here was... It's not that there's no unsympathetic barristers. Anthony Kerr and so on, I'm sure, would be sympathetic. But nevertheless, maybe it's because he's got a lot of experience in this. But he said in a talk, which is, I just got today, it's on the Congress website, he made a presentation, a lecture rather, and he said it's more striking still that the Supreme Court made no reference, the point I've made just a moment ago, I got from him. So perhaps this activity is a recourse to Europe, may signal a change of the tide, but let's hope. Thank you very much.
Thank you very much, Tom. That was, I thought I knew something about this, but after having listened to that, there's an awful lot that I don't know.